And Binta in Nyako, a federal high court judge, has rescued herself from presiding over the case of Nnmadi Kanu, leader of the proscribed indigenous people of Biafra, IPOB. Kanu directly told Nyako that he no longer had confidence in her handling of his trial, while his lawyer, Nnmadi Kanu, was trying to persuade the court to suspend the trial on the basis that his client was denied the opportunity to prepare his defense. Kanu sprang up from his seat and ordered him to sit down.
And in 9 charges leveled against me. This place where I committed this crime was London, the United Kingdom. Yes. When my lawyers came to see me, I had a discussion with them about how I'm going to defend myself. I told them that no court in Nigeria has jurisdiction to try me. Because since this offense was committed in England, so they said, it's only a UK court that can give a Nigerian court the authority to proceed, isn't it? Yes. They charge again and remove London.
Location of the
broadcast. Location of the broadcast. Contrary to section 196,
174 of the Terrorism Prevention Act 2022.
In violation of their own laws. In violation of their own laws. And you want me to stand trial under such circumstances? Is that possible? Nnamdi Kanu to stand trial where all these shenanigans are going on? It's not possible. On IPOB, trying to use the name of IPOB, trying to subvert the will of the people, our principles and our core values. That person has a lot to contend with when the time comes. You can run, but you can never hide. You can run and hide and be talking all manner of rubbish, but one day we'll catch up with you.
Counsel to the federal government, Adegboyega Awomolo, had told the court that he had a witness in court and was ready to proceed with trial, while the court was setting up a protection screen to shield the witness. Nnmadi Kanu, who was the counsel to Kanu, told the court that his team was not ready to proceed with the trial. Nnmadi Kanu said his client has consistently been denied the opportunity to adequately prepare for his defense.
This is why trying to get fair hearing. And if this fair hearing cannot be guaranteed in this court, then we need to try another court. The Constitution is very clear on this. Section 36 made it very clear that he deserves, as of right, the adequate facility to prepare for his defense. And who prepares him for his defense? His defense counsel. Only we do have 3 appeals. One goes to restoring his bail, which the Supreme Court severely criticized the revocation of his bail by this High Court. And the other 2 go to the jurisdiction of the High Court to try him for these offenses. So what is really the essence of rushing to trial when you have these 2 situations militating against such trial? So we took that position and we tried to relay it to the Honorable Court, but the court was insisting in the face of all this, especially the injustice of not allowing him his constitutional right to fair hearing. The court was insisting on proceeding to trial. That left our client with no choice than to express his loss of confidence in the impartiality of the court. That's what happened. That's why he requested for the judge to recuse herself.
Well, although the prosecution had urged the court to proceed with the trial, Nyako said she would go with extricating herself with the case. She said she would be sending the case file back to the Chief Judge for reassignment and further necessary actions.